Okay, well, season's greetings to our Greater Boston Humanists for our December gathering and talk. Just a quick note, we have these on Sundays, these talks of ours, our monthly talks, in order to keep the tradition of our usual live meetings alive. We had hoped to start again with our actual in-person meetings after the vaccine access by this fall, but the new COVID variants are making that dangerous. So thank you for taking time out on a Sunday for merely a Zoom meeting. Also, our thanks to Joe Gerstein and Smart Recovery, and an alternative addiction treatment program based on science, for letting us use their Zoom account for our meetings during the pandemic. As a result of the virtual option, we have the opportunity to hear from a greater variety of people from further afield. And today we're going to hear from an attorney from the National Office of the American Humanist Association in Washington. So I want to take this time to welcome all humanists, atheists, free thinkers, and other skeptics and critical thinkers, as well as our special guest, Katie McKerall. We are going to do a land acknowledgement now here in Boston. We acknowledge the land where we work, live, learn, and build community has been a place where people have lived for over 13,000 years. This land is the territory of the Massachusetts, Pawtucket, and their neighbors, the Wampanoag and Nipmuc peoples. We wish to respect the continued connections with past, present, and future in our ongoing relationships with Indigenous and other peoples in the greater Boston area. We would like to invite all to get involved in anti-colonialist and Indigenous land struggles wherever you live. I'm going to put some links in the chat for getting involved. Most of you are no strangers to humanism and what it stands for. We are good without gods. Check out the chat area also of the Zoom meeting for some basics on our group and other local secular group links. I just have two announcements for other upcoming events. Saturday, December 18, next weekend at 4 p.m., the Free Thought Society, which is based in Philadelphia, is holding a virtual national Human Light celebration. Human Light was first celebrated in 2001. So this 2021 event celebrates the 20th anniversary of this humanist-oriented holiday celebration. So have a beverage of your choice available for a toast to this festive occasion. They write, the artist Rogier, director of Black Nonbelievers, Washington, D.C., will be the master of ceremonies and perform a version of John Lennon's Imagine, along with welcoming many artistic performances to celebrate that with that group. And then 2 days later, on Monday, December 20th, in the evening at 7:30, Greater Boston Humanists, our group, will hold our Happy Humanist, Happy Holidays virtual happy hour social at 7:30 p.m., as I say, at the same Zoom address that you're at now. So without further ado, Katie McKerall is a staff attorney at the Appignani Humanist Legal Center of the American Humanist Association. Prior to joining AHA, she worked as a staff attorney in Fairfax, Virginia, and as grant writer for the Rappahannock Goodwill Industries in Fredericksburg, Virginia. Originally from Gulf Shores, Alabama, with a philosophy degree from the University of South Alabama, Katie is passionate about protecting and fostering a free and open society through the First Amendment, and worked in the Free Speech Clinic while attending law school at George Mason University. Her topic today is the Boston Flag Case and 2022 Speech and Religion Legal Concerns. So welcome, Katie.
Thank you, Stuart. Can everyone hear me okay? Getting some video glitch on this end, but if audio is fine, then we'll be fine.
I'm not seeing a video glitch. Maybe others are, but anyone that has any audio issues, please raise your hand or put up a signal.
As long as you can hear me, then we're good. Yeah, so as Stuart mentioned, I'm a staff attorney at the Appignani Humanist Legal Center, and which was established in 2006, and our mission is to defend our constitutional right to a secular government by strengthening the wall of separation between church and state. We do this through a variety of means, mostly bringing cases at the trial and appellate level. We also file friend of the court briefs in various relevant cases, and do things like send warning letters out to schools or other organizations that are participating in practices that violate the Establishment Clause of the Constitution. So the main thing that, does anyone have any questions about the center before I move on to the Boston flag case? Nope, good, okay. So, and I'm not exactly sure how to pronounce the petitioner's name in this case. I'm gonna go with Shurtleff v. City of Boston. This was a case out of the First Circuit, which SCOTUS, the Supreme Court has granted cert, and they will be hearing oral arguments on January 18th. Should be an interesting thing to listen to. So in this case, the City of Boston has a program where they will allow a third party to fly a flag on one of the 3 flagpoles in front of City Hall, usually in conjunction with some event that the third party group is holding. So they've been doing this for quite a long time. So there's three flagpoles. One of them has the American flag, another has the Massachusetts state flag, and the third flagpole is usually carries the city's flag. When an organization applies to and is granted permission to fly a flag, the city flag is taken down for a period of time. It's usually, no more than an hour or so, from what the record looks like. So this organization called Camp Constitution, which is kind of I don't know too much about the organization from the record, but essentially it's teaching about the Judeo-Christian origins of the United States. So it's kind of history with through a Christian lens. They wanted to have an event in one of the areas around City Hall, and they wanted to fly the Christian flag, which has a Latin cross on it. The city declined. They were still going to let them have their event, but they didn't want to fly the Christian flag on this third flagpole. So Camp Constitution sued. They lost at the district court level, and then they lost again at the appellate level. And now they've taken it to the Supreme Court. But what the First Circuit held was that this was not discriminatory against Camp Constitution, because the flags, the flagpoles, it was not a public forum so we're going to get a little bit into some First Amendment jurisprudence weeds here. So the government can't discriminate when they create what's known as a public forum. The government cannot discriminate against a speaker based on the content or the viewpoint of their speech. They have to take all comers. But what the First Circuit said was this was not a public forum. This was government speech. And the First Amendment rules about viewpoint neutrality do not apply to the government. The government does not have to be viewpoint neutral when it speaks, because that would be kind of paralyzing. Sort of necessarily when the government takes viewpoints on a variety of issues, and they would not be able to operate they were forced to be viewpoint neutral. So the First Circuit said this is government speech. This is not a public forum. Therefore, there's no violation of the First Amendment. So now that it's going to the Supreme Court, I just want to stop and see if anyone has any questions so far about things. Like I said, my video is still kind of lagging a little bit, so I'm not sure if I'm seeing if anyone raises their hand. So if you do have a question and you raise your hand and it doesn't seem like I see you, please just unmute yourself and yell at me. It's totally fine.
I have a question. Where is the raising the hand icon?
So if you move your cursor over the bottom section of the Zoom screen, you should see a sign that says reactions. It's got a little smiley face.
Yeah.
And if you tap on that, there's a raise hand button.
Got it. Okay, thanks.
Sure. All right, so I think, given the makeup of the Supreme Court right now, it's a very strong conservative majority on the court. My feeling is that the Supreme Court is going to overturn the First Circuit's decision and say that this was discrimination, and that it was a public forum and not government speech. But I don't think that's as scary as it sounds. Just because the free expression, the free speech and free expression parts of the First Amendment, they apply equally to all of us, right? So the government being able to silence this viewpoint means they could silence any viewpoint that they wanted to. So this time it was a religious viewpoint, but it could be, an atheist viewpoint. It could be a political viewpoint, and the city does have an interest in remaining neutral. So the problem that I think many of us see with this getting overturned is that it does look like government endorsement of religion in some sense. And I see why the First Circuit came out the way it did, because just to give you an overview of how the court decides when something is government speech, there's sort of three main factors that they look to. Number one is the history of the medium involved and whether or not the government has used this kind of medium to speak in the past. The second is how closely people identify this type of medium with the government. And the third is the degree of control that the government exercises over the medium. So in this case, number one, the history of the medium, governments have used flags to express any manner of views and positions for a long time. I mean, every country has a flag, every state has a flag. So this has been a method of government communication, for centuries. So that is in the government's favor, for sure. How closely people identify the medium with the government, I think the way the First Circuit framed it does make sense. We're talking about 3 flagpoles in front of City Hall. Who else would you associate these flagpoles with, if not the government? And then the third one, the degree of control, this is where I think it gets a little stickier, because the city does have an application and approval process to fly the flag at City Hall. However, out of I think it was like 284 applications, Camp Constitution was the one time that an application was rejected. So every single other time the application was admitted and the flag was flown. And in every other case, the government official who's reviewing the applications never even looked at any of the flags. Now, part of that is because a lot of them were sort of familiar from a cultural standpoint. So, you know, some of these other events would be to recognize and raise awareness about different cultures. So the Portuguese flag or the Turkish flag, things like that. So the government official didn't really need to see a photo of it to understand what it was. However, in this, you know, it's really interesting because, and I hesitate because you can see how it could go either way. Yes, they have some control because you have to apply and be accepted to raise the flag, but that doesn't necessarily make it government speech. There are a series of Supreme Court cases that discuss what's known as a limited public forum. So it's a little bit different. So a traditional public forum is a place like a city park or a sidewalk. It's a place where anyone can be and anyone can speak and express themselves. So that's a traditional public forum. A limited public forum is a place that the government has designated to be a public forum. So there's a few Supreme Court cases that involve public schools who will open up meeting rooms like their gymnasium or, you know, something like that to outside groups to use. And in a couple of cases, they have not permitted religious groups to use the school gymnasium to talk about, for instance, family values from a religious standpoint. And what the Supreme Court said in those cases was the school had opened up this limited public forum. And now that they've done that, they can limit sort of the topics, the content, if you will, but they can't discriminate based on viewpoint. And the court found that, you know, for instance, family values from a religious perspective, that was a particular viewpoint about the family, the topic of the family. And so the court, or excuse me, the school could not discriminate against this group based on that viewpoint. And so that's why I think this is going to go the other way after the Supreme Court hears oral arguments, because I think they're going to say, yes, you know, and with the same thing with the school and the gymnasium, you can't just walk in there. You know, you have to get permission first. But once you get permission, you can kind of talk about really, you know, a range of things. And the school doesn't control that, just as the city doesn't control the events that are occurring along with these third-party flags that are flying. So that was a little bit rambling, but I want to pause again and see if what I'm saying is making sense to you guys, if you have any questions so far.
I have a quick question. So the other groups that have applied have chosen what flag they want to present. but there's been no control over the content of their presentations apart from the flag, right? Or even including the flag.
Correct.
But none of them have chosen as a flag something that is mostly almost entirely identified with a religion and not
That's
with a
correct.
particular group, right? It's literally a religious flag.
Yes.
As opposed to, a national flag, yes, it represents a group, but it's a nation, and everyone knows that that the city hall is not in another nation, so there's no question. But in this case, it almost says city hall is now, I can see the argument that it endorses Christianity.
Oh, absolutely. Absolutely. And I think that is what the city was trying to avoid. They were trying to avoid being seen as endorsing Christianity. But just, and I think if we had a different makeup on the Supreme Court, that this decision would likely stand. But I think the makeup of the court as it is now, they're going to reverse on this, and they may find other ways to do it. As I was rereading through the case, I think they could make the argument that it was a limited public forum and this was viewpoint discrimination. So that doesn't really have to implicate either of the religion clauses of the First Amendment. But I think that they also have the option of saying that this did discriminate on the basis of religion, these people having a religious viewpoint, because even if it's government speech, the government still can't violate the free exercise rights of a group through its actions. And they again, the current makeup of the Supreme Court, they kind of jump through some really interesting logical hoops in order to find for these religious petitioners. It's kind of another recent example is Fulton versus the city of Philadelphia. I'm not sure how familiar you guys are with this case, but this was a case where Catholic Social Services in Philadelphia, they partner with the city to provide foster care services. And Catholic Social Services said, our beliefs prevent us from certifying that any LGBTQ plus individuals are approvable as foster parents in the system. And the city said, well, that violates our anti-discrimination laws, so we're not going to partner with you anymore, Catholic Social Services. We're not going to renew your contract. And the Supreme Court found that the application of the anti-discrimination law to the way they applied it to Catholic Social Services was discriminatory based on their religion. So they didn't apply their anti-discrimination policy neutrally to Catholic Social Services. So the court didn't say that Catholic Social Services could discriminate against LGBTQ individuals. What it said was the city was not applying its own anti-discrimination law in a neutral manner. So this is how they're able to, they get to the result that they ultimately want to without saying the thing that they aren't really supposed to say, if that makes sense. So, it's a very stressful Supreme Court term this year. This October sitting is it leaves a lot to be desired. So Any other questions about the flag case, or any other cases in the pipeline?
I will just quickly say, I'm sure a lot of people have questions about a lot of the really key cases coming up, but as back to the one more quick thing about the flag one, I just read in the New York Times that the ACLU came out in favor of overturning the circuit court decision. So I'm wondering if that's, you think strategically, because, well, one thing is it's a free speech, maybe no brainer, I don't know, for them, but or they don't want to die on that hill because they don't want to be seen as just being so hostile to religion that even in free speech cases, like this is being cast as a non-neutrality case, right? That they don't want to be seen as so in that court that they won't be listened to, so in that side that they wouldn't be listened to in their other arguments.
Yeah, well, that's interesting. You know, it could be strategic. And I have read their amicus brief, and they make the very argument that I, you know, just outlined for you guys, that this was a public forum and this is viewpoint discrimination, and that it's not acceptable. You know, because the fear, at least according to the ACLU's amicus brief, is if you classify this as government speech, you're expanding the government speech doctrine. And what's really dangerous about that is that if all that is required for it to be government speech is that, you know, you have to fill out an application, or, you know, you get some kind of stamp of approval, then the government can censor just about anything that it wants. And, you know, there was a landmark case just a few years ago regarding government speech, Mattel v. Tam. I don't know if you guys remember or were aware of this. This was a trademark case in which a band made up of Asian Americans, the band name was the Slants, and they wanted to, which is a, you know, kind of a disparaging term for Asians, and the Patent and Trademark Office rejected the trademark because they said it was, you know, just it was inflammatory and disparaging to a group of people, and it went all, you know, and the band's reasoning for doing it, it was sort of like, we're going to take this word back and we're going to, you know, we're going to sort of cleanse it of this, you know, disparaging stench by claiming it. And so the Supreme Court said, you know, if all it takes is registration with the Patent and Trademark Office to turn private speech into government speech, then, you know, the government is babbling constantly and incoherently about everything under the sun. So, you know, every slogan you've ever heard on a commercial would be government speech. And so you can see how that would be not great, because then they get to control everything. So we want to keep the tent of what counts as government speech as small as possible. And if we, you know, so it's kind of a slippery slope argument, but it's also, you know, we're just, it's protective of the free expression clause more than advancing religion, is kind of the way that I see this case, if that makes sense. Yeah, any other questions? I like the you know, interactive aspects of these meetings, so don't let me just ramble on and on. Feel free to jump in and you know, challenge or questions, or, you know, whatever's on your mind. Okay, so, well,
Katie, I have a question.
Yeah.
Now, this case pertains to Massachusetts. It's a case in Massachusetts. Are there similar situations in other states? Do they have a system where in front of City Hall? By the way, is this for the whole state or is it just for the city that this case applies to?
So the party to this case is the city of Boston.
Okay.
So it is only the city's flagpoles that
Okay.
are at stake. Now it would have broader implications on other, similar type programs throughout the country, because it is at the Supreme Court level now. So whatever they decide will apply, across the board. I'm not aware of whether other municipalities have similar flagpole programs, but I have heard about cases where, so for instance, one of the cases that the First Circuit relied on when deciding that this was government speech was a case, I'm going to blank on the name. However, it involved a city park as opposed to City Hall. But what happened in that case was the city had accepted a number of monuments and statues that were donated by third parties. And one of them was the 10 Commandments. And another religious group offered a statue of their religious tenets, and the city rejected it and said, well, we're not going to put this in the park. And so the religious group sued. It made it all the way to the Supreme Court. In that case, the Supreme Court said that the monuments, even though they were donated, the monuments in the city park were government speech. And so the city was not required to be viewpoint neutral, that they could pick and choose which messages they wanted to send. And I think one of the big differences there was that these were permanent statues that, in a city park, and they use the same, 3-factor test, whether the use by the government, whether people associated the medium with the government, and the degree of control. And so they found that was government speech. So you can see how, the devil's in the details, as they say. So permanent monument, government speech. But I think temporary flag flying, they're going to find to not be government speech in the long run.
Thank you.
Mm-hmm. Let's see. So there was a number of other cases in the Supreme Court that that implicate religion issues. And one that they just heard oral arguments on last week is Carson v. Macon. And this is the case involving a public tuition assistance program in Maine. And this one is a little more worrying, but again, the court finds ways to get where they want to go without saying what many of us think they really are thinking. So in Maine, there are several school districts that are so rural that they do not actually operate a public school. So what the state enacted a statute that says, if you live in one of these districts, we will give you tuition to attend a private school of your choice but it cannot be a school that endorses a particular religion. So the interesting thing about this is they don't rule out all private schools that are religiously affiliated. If the private school remains neutral as far as religion, then they can be accepted into this program and they can receive this tuition money. However, if the school is overtly religious and has mandatory chapel, or teaches that just particular religious precepts, they're not eligible for this program. So 2 families who wanted to send their children to private religious schools, which the schools they wanted to send their children to were not accepted into the program, so they sued. And it's all the way, as I said, the Supreme Court just heard oral argument on it last week. And I think the reason that the court is going to get to say that this was discrimination and the state can't do this is because instead of the state handing the money to the schools, the state hands the money to the parents, who then hand the money to the schools. So the way the parents are framing it is that this is a parental choice that the state is taking away, as opposed to what's really happening. The state is trying to avoid financing any particular religion because that would not be acceptable. But their argument is that somehow by simply having the parental middleman take the money, it cleanses it of any government involvement in religion. And so that's another interesting one. And again, so again, the Supreme Court's going to get to the answer of, no, we're going to let these parents choose religious schools to send their children to with this public money that's being given to their parents. But that's okay. But that's not financing religion. That's financing the parents. And so that's kind of the fine line, distinction that is going to mean that Maine taxpayers are going to end up footing the bill for religious education for particular students. So that one's a little more concerning to me. Because it gives a clear message of here, there's an easy workaround to the government funding, the prohibition on government funding religion, and that is you just feed it through individuals first. So that's what's happening with that one. There is another case, I think I can't remember if they heard oral arguments on this one or not, but there's a death row inmate in Texas who would like his pastor to be in the chamber with him when they administer the lethal injection, and would like the pastor to lay hands on him. And so we filed an amicus brief, or signed on to an amicus brief, and that one basically saying that the death penalty is a religious holdover in and of itself and should be banned. So that one's interesting. Any questions? I feel like I'm just rambling on and on.
Could you, I didn't quite get that Texas case. Could you say a little bit more about it? What is it that it says in terms of, I don't understand exactly what you is.
Yeah, sorry, I glossed over that pretty quickly. So there's a death row inmate in Texas who so Texas has had a history of allowing state-sanctioned chaplains in the execution chamber. And then a Buddhist inmate who was also a death row inmate wanted, they didn't have a Buddhist chaplain. So he wanted someone that from his own faith to be allowed in the room with him. And so the Supreme Court through Justice Kavanaugh said, well, yeah, Texas, what you really need to do is decide either you let everybody in or you don't let anybody in. And so Texas was like, oh, okay, cool. So we just won't let anybody in. And so now we have the second death row inmate who I believe he is a Christian denomination. They don't really talk too much about what his affiliation is, but he would like his pastor to not only be in the chamber, who is not employed by the Department of Corrections, which that was their original policy, was if the chaplain was employed or approved by the Department of Corrections, they would be allowed in. So this particular inmate, his pastor does not work for the Department of Corrections, but he would like this person to be inside the execution chamber with him, laying hands on him at the moment when, he dies. And so Texas said no. And so he sued. And so now it's at the Supreme Court level. And I think they did have oral arguments, because now I'm remembering that several of the justices expressed basically skepticism that this was actually a sincerely held religious belief, and that really what this guy was doing was just trying to stall, and slow down the clock, buy himself a few more weeks or months. So the interesting thing about that is the idea of questioning someone's sincerely held religious beliefs has been a definite no-no for the Supreme Court for decades. So it's very strange, to say the least, that suddenly in this context, they're doing just this very thing. They were for instance, in the Hobby Lobby case, which you guys probably remember that one from a few years back, they said repeatedly that we are not going to question, this corporation's sincerely held religious beliefs. But this guy on death row, suddenly they are going to question them. So it's a very strange, 180 in that case. And we'll see how that goes. It's probably not going to work out well for the inmate, would be my guess. So I think those are most of the Supreme Court cases this term that have to do with religious issues. Is there anything else you guys are wondering about?
Excuse me. I just have a question, and I probably I'm not computing that well today. But in reference to the Boston flag situation, did you say this is the first time that a religious flag has been presented?
Yes.
For approval? Okay.
Yeah. Now, so the first time it's been an overtly religious flag. So, I mentioned the flags of Portugal and Turkey, and the reason that those were mentioned in the First Circuit opinion is because Camp Constitution tried to use these flags as examples of, look, the city these flags have religious iconography in them. I believe the Turkish flag has the the star and crescent, this Islamic symbol. And I believe the Portuguese flag has some Christian references in it. But as we said earlier, these are flags that represent countries, and they just happen to have religious imagery in them. So this was the first time that it was only religion was the only sort of meaning behind this flag.
Okay. Yeah, I was wondering because I live in Brookline, Massachusetts, and about 2 years ago, it's pre-COVID, a flyer for the organization, the Camp Constitution, was left at the library. And I was like, oh, what is this now? And I looked through it and I was like, wow, this is some interesting stuff. This guy used to be big in the John Birch Society. When I went on the website, I saw, this like hatred of the UN, and just recently they have one of their guys offers one of his talks is on of course critical race theory and how it's racist and all this stuff, and I'm like, okay, so that's what this is. Actually, it's actually, yeah. And then of course, wasn't this also in reference to an event that they wanted to have as well?
Yes.
Oh, great.
And so the interesting thing is the city didn't try to stop them from having the event. They said, well, you can still have the event, we just won't fly the flag. And that wasn't acceptable to Camp Constitution. So
yeah.
So they didn't have, I don't believe they had the event. They did apply twice. And the second time the city just didn't even respond. But because they basically thought, well, we already told you guys, one time. But yes, so they weren't going to, so that's kind of what makes it even more interesting, is that they weren't going to stop the event. They were going to let them have the event and, make whatever comments they were going to make, but they felt, and maybe, again, different Supreme Court would probably could come out saying, well, they were going to let them have the event, so they were going to let them express the ideas. They just didn't want to do the one thing that would have associated those ideas with the city government.
Yeah.
So it seems like a pretty reasonable compromise to most of us, but of course, not to Camp Constitution. So yeah, so we'll see.
And when it does happen, you said on the 18th, was it?
Yes, I believe it's January 18th. Mm-hmm.
And is that something that can be viewed by the public?
So you can listen to it, and there's a lot, usually, so I've tried to listen to it on the Supreme Court's website before. They supposedly will live stream the audio, but it's never worked when I've tried to do it. It's usually posted there afterwards, but a lot of times NPR or C-SPAN, I think C-SPAN probably does it every time. So I've listened to it live streaming on NPR. I've listened to it after the fact on C-SPAN. You should be able to, if you just Google Supreme Court oral argument streaming, you should get some options to listen to it.
Oh, thank you so much.
Yeah, absolutely. I just want to switch gears for a brief minute and tell you guys about one of the big cases that we have at the Legal Center right now. We have a case that is in the 11th Circuit out down in Florida, and this is kind of an interesting case where the City of Ocala Police Department conceived of, organized, promoted, and then conducted a Christian revival type prayer vigil in the downtown square. And we had several AHA members who, you know, they heard about it, they promoted it on Facebook. And so we had some members that heard about it and they contacted us, you know, and they contacted both the chief of police and the mayor and tried to tell them that this was going to violate the Establishment Clause of the First Amendment. And they did not care to hear that. So they had the prayer vigil anyway. And so we sued them and we won in district court. We just recently, back in October, filed our opening brief in the 11th Circuit. So not sure, you know, the wheels of justice grind slowly, as they say. So not sure when we will hear something, but we should. That's moving along. So we're pretty hopeful. We think the other side is gunning for the Supreme Court with this case as well, because for the appeal, the defendants have hired a couple ex-Trump attorneys, so it should be very exciting stuff. So you can stay up to date on that through, you know, the AHA and Humanists Legal Center website. So that's pretty interesting. Let's see. What do you guys want to know about?
Well, Katie, my understanding is that a lot of the Appignani Center's work involves finding out about potential violations and then sending them threatening letters, and then they usually back down so that you don't actually have to go to court in many cases. Is that what percentage of your cases is like that? And
so I couldn't tell you percentage off the top of my head, but it is often the case that you know, a strongly worded letter will resolve the situation. We actually had one recently, well, 2019, where we sent a warning letter to a public school in Iowa because they were planning a religious field trip. And they actually ended up canceling the field trip the day before it was scheduled to happen. So so that was kind of a win. You know, sometimes what happens is we send the threatening letter, the violation stops, but then sometimes the lawsuit will happen anyway because the harm has already taken place. For instance, another case that we have in Oklahoma, an elementary school was conducting a program called Missionaries, which is quite a lot like it sounds. They had local individuals who would come in and basically preach Christianity and, you know, sort of pro-Jesus things to a captive audience of children as young as 3. And actually our clients, their child was 3 or 4 years old when she was first exposed to this practice. And so they've since stopped the Missionaries program, but it went on for so long, and, you know, was really just such an egregious violation that we kind of felt like we needed to go through with the lawsuit anyway, just because it was, you know, just to kind of cement the idea that this is not okay. This has never really been okay. So yeah, but a lot of times the warning letter is almost always the first step at the very least. And as I said, you know, we also file amicus briefs, not only in the Supreme Court, but in circuit court cases. Like, for instance, the Boston flag case, we filed an amicus brief when it went to the First Circuit. in favor of the city, obviously. So, you know, that's something else that we do. We do talks like this. And, you know, our legal director, Monica Miller, she does YouTube videos called Legal Tuesdays. I don't think it's every Tuesday. It might be every other Tuesday. And where she answers questions about the Establishment Clause. And those are posted on YouTube as well. So that's kind of a fun resource to learn more about what we do and what an Establishment Clause violation looks like.
Strategically thinking. Go ahead, Micheline.
Several of the cases that you're talking about or mentioning, for example, the missionary case, etc. Now, the objection to that and talking to the children is because the talks or whatever are funded by the government as opposed to be privately funded, because kids, like in the case of well, let's say missionary talk, is talked about in churches. So,
Right.
so the cases you're talking about are cases that are supported and promoted by governments. Is that my understanding correct?
That's correct. In this case, this was at a public school. This is a public school
Public school,
setting.
okay.
And that's if it was a private school, if it happened in a church, even if it was, you know, a religious group rented out a community center to have this kind of program, these would all be okay. But it's not okay because it is happening under the auspices of a government institution, namely a public school. And, you know, these kinds of cases involving children are, in my opinion, even more concerning because, number one, they are young, impressionable minds, you know, and so this is kind of a form of indoctrination. And number two, because they are so young and impressionable, they are more susceptible to government coercion into at least, you know, mouthing agreement with the government's point of view. And so, you know, bringing religion into public schools is, in my opinion, one of the worst of the types of violations that are out there. So.
But if the same thing happens in a non-public space, then you can't do anything about it.
Exactly. We just want to keep religion out of the government. That's our main objective, is we want to keep the government secular. We want to keep the government neutral to religion. In part because the danger is, if the government can show favoritism to one religion, then they can show favoritism to the individuals who identify as part of that religion. And the flip side of that is that if you're showing favoritism to members of one religion, then you are discriminating against everyone else. And, you know, since as humanists, we don't have a religion, you know, we often would fall under the, you know, the discriminated against category. And so that's, you know, it's part of just protecting the rights of our members.
Great. Well, thank you very much. If you could, you know, if anybody else has any other questions, please, and that could be about anything to do with the judicial system and these and other issues. I know a lot of us are really concerned about the current makeup of the court and what they're likely to do and have been doing in these abortion cases. But I wanted to ask you if you have any characterization, Katie, of the sort of strategies of the religious right and how they're being pushed forward through a new legal theory. I sometimes hear about this sort of religious rights theory, or the idea that religious people are the ones who are the victims and being discriminated against. Is that seeming to be the trend?
In a way. So I feel like what we're seeing a lot of is cases where religious individuals are basically claiming that government neutrality towards religion is actually hostility towards religion or discrimination against religious individuals. And so it's kind of it's like it's a shift in perspective, I guess. So it kind of, yeah, I mean, it's sort of, they're not putting it in the exact terms that, the way that you did, Stuart, but they are basically saying, well, if the government stays out, if the government doesn't give money to these certain religious groups, it only gives money to non-religious groups, then that in itself is discriminating against religion. It's choosing non-religion over religion, which the Establishment Clause also says it can't do. So, and sometimes it works, honestly. Sometimes it doesn't. And we are in this state where whether or not it works kind of depends on where in the country you are, unfortunately. Where you guys are, you've got a much better chance of the court not buying that argument and saying, no, this is not discrimination, this is neutrality. But, down in the 11th Circuit, Florida, Alabama, Georgia, it's more likely to go the other way. So that's, and one thing I would, if I can give a little, I don't know, counter pep talk, because the thing is, the religious right, they're very organized, right? They're very organized, they're very loud, and there's not really that many of them. There's not as many of them as it seems like. They have an outsized voice. I think the last time I looked at statistics, though, individuals identifying as, nuns or atheists or humanists or agnostic or undecided, we're a quarter of the population of this country. And so we have strong numbers, really. And, so things that we can do, we need to get our voices out there. We need to be visible and more visible in the community. We need to show up to school board meetings. We need to, show up to debates and attend these government events. And, even just having a bumper sticker on your car saying that you are a humanist, or, having the flying spaghetti monster on the, something like that, just so that people know that we're here, and of course, voting is so important, because with the state of the courts right now, the other branches of government are they're all supposed to balance each other out. So we just really need to get out there as much as we can, and just make our voices heard. And also, if you see something that you're wondering if it's a violation, we have a form on our website, on the Appignani Humanist Legal Center website. We have a report a violation form, which if you just fill it out, it comes straight to me. And we try to get back to people within 24 hours. But even if you're just wondering, is this a violation? Is this something that we need to be concerned about? Because it is very nuanced, and and it can be very confusing. So as they say, knowledge is power, and that's one of the things that we're here for too. So if you ever have a question about whether something is a violation of the Establishment Clause, please, send us an inquiry through the website, and we will get back to you. And if there's something there, then we'll talk about next steps. So we're here for you guys. So
Great. Well, thanks so much, Katie. I noticed that I didn't know it before today, but the website is humanistlegalcenter.org. That's right.
Yes, I believe so.
I followed a link from the AmericanHumanist.org. So.
Right. And honestly, that's how I get there most of the time. Just going through the main.
I was going to note the good thing about humanistlegalcenter.org is that it's pretty easy to remember. So if you know anybody in your family or friends or whatever living somewhere and they wonder to you, oh, this sounds wrong to me, what do you think? I mean, you can definitely tell them, hey, just email Katie at this or our center, and they'll look into it for you. So that's helpful. And can you, just one last thing, if you could mention, there was some kind of demonstration that AHA took part in on December 1 at the Supreme Court. Is that right?
Yes, and that was the day the court heard oral arguments in the Mississippi abortion case, the Dobbs versus Jackson's Women's Health. So we organized in support of maintaining, the constitutional right to choose what happens to your body. And yeah, that was, you can go, those oral arguments did already happen. And so if you are interested in suffering through 2 horrible hours, then I recommend going and checking it out. It was, yeah, so that was what the rally was around. Because Mississippi, so they've banned essentially all abortions after 15 weeks. And the, the standard set out by the Supreme Court in Roe and later Casey is viability, which is, the limit is viability, which is about 22 to 24 weeks. So anyway, but the unsettling thing about that case is that the actual question that was certified for the court to answer is, are all pre-viability bans on abortion per se unconstitutional? And I think because of the way that that question is worded, I think the court is going to be able to say, no, not all of them are not all pre-viability bans are unconstitutional. And yeah, so very concerned about Roe v. Wade right now. Not looking good. I could be surprised. Justice Sotomayor, gave probably the best line from those oral arguments, which was, asking whether or not the Supreme Court could survive the stench of, overturning Roe v. Wade, and the partisan implications that would have. But I'm not sure the conservative justices really care too much about how they smell. So, yes. So again, we'll see. We'll just have to wait and see.
What I think is possible is that they may continue to uphold Roe v. Wade, but gut it of all meaning. I think it's the more likely option they'll choose. Just partly because of so much case law, it's built on Roe v. Wade, which we have, a lot of the case law has nothing to do with abortion. So instead of overturning Roe v. Wade, they'll just gut it of all meaning.
Yep. That's a distinct possibility. Well, anyway, it's
Yeah.
causing sleepless nights, but
It's very depressing, but it may be up to us at that point to make it clear to everyone that this supposedly nuanced ruling where they don't officially overturn it really is the same thing, and that we need to all mobilize. I mean, those who believe that this is the right way
Right.
of approaching that question, which in
Right.
some ways is a religious question.
Well, right, and that was I forget if it may have been Sotomayor again, asking the state, how is this belief like anything other than a religious belief that life begins at conception, and the respondent didn't really have a good answer, because it's not based in science. It's based on our religious belief, and so it really is the state of Mississippi deciding that it's going to, that it shares this religious belief that life begins at conception, and is forcing this religious belief on everyone who lives there. So, but yeah, I don't think the court is going to. The majority of the court won't see it that way, and Barrett just kept asking about safe harbor laws that let you drop your newborn baby off at like the fire department after, and asking, well, why doesn't that just take care of it? Like, why isn't that enough? So that was interesting as well. So yes, Supreme Court's very busy this term. So many things happening.
Well, thank
which is
you all.
why we have to fight all the more. Okay, sorry.
Well spoken, well spoken. Thanks so much for visiting us today and letting us ask questions. And again, Katie and the staff of the Legal Center are always available at humanistlegalcenter.org. And I wish you all the best of this holiday season. And don't forget our social event, which will take place Monday, the 20th at 7:30. And all of our events and other secular local events are listed at bostonhumanists.org, which leads you right to our meetup page. So thanks again. Oh, and Deb, I guess
I have one last question for Katie, sorry.
Sure.
In that Mississippi case, does it prohibit people from leaving the state to have an abortion after the 15 weeks? And also, does it prohibit anyone for giving information like the Texas one does?
Not that I'm aware of. I think as far as, and I haven't read all the materials to go along with that case, so there could be something I'm missing. But as far as I know, the Mississippi case, the Mississippi law is just a straight up ban after 15 weeks. But the Texas case is, that's gonna wind its way through the courts for probably years before it, gets back to the Supreme Court. And as you've alluded to, it's designed to get around any traditional legal challenge that has been brought, before against this a state statute. No government official can enforce the ban in Texas. It's all on private individuals reporting. So there's no one to sue. There's no state officials to sue. The abortion providers have found some, and the Supreme Court recently did rule that with the Texas abortion law that the abortion providers can continue their suit against some state regulatory individuals. So the the organization that, what's the word, that basically oversees physicians in the state of Texas and has sort of certification power and sanctioning power for kind of malpractice type things. So they would be the organization that would enforce any kind of punishment against the physician for aiding and abetting, or for performing an abortion or providing information about an abortion. This would be the agency that would actually carry out any sort of sanction. And so the Supreme Court said that the insurance providers can sue them, because the thing is, normally it would be, you know, like the Attorney General or the governor. But because the statute is actually written to say that those people aren't enforcing the statute, so you can't, they don't have anything to do with it, so you can't sue them. So they're, and Texas wrote the law this way on purpose. I mean, it's very sort of esoteric and strange, but they wrote the law this way on purpose to try to prevent anyone from bringing any challenges to it. So, but that's, you know, that's got a long way to go before it gets to the Supreme Court. But in the meantime, there's essentially no abortion in Texas right now, because they did not, you know, the Supreme Court declined to enjoin the law while it's making its way through the court system. So there is no abortion care in Texas, probably for the next several years. So. So on that happy note, thank you guys for having me today. This has been, and listening to me just ramble on. It's been a lot of fun though. I hope you guys have gotten something out of it. And yeah, if you have any questions, or, you know, we're just wondering about, you know, anything in particular, you know, like I said, feel free to fill out the form on the website. And actually, Stuart has my email as well. Very happy if Stuart, if you're welcome to share it with any of the members. If you guys want to reach out and directly and ask me any questions about anything. So I'm gonna shut up now, but thank you again.
Thanks so much.
Thank you.
Thank you.
All right.
And
Happy
again,
holidays.
happy holidays, everyone.